Article 4 of the Civil Code of the Philippines states that laws shall have no retroactive effect unless the contrary is provided. The general rule is based on the maxim lex perspicit, non respicit, which means that the law looks forward and not backward. So while the judge looks backward, the legislator looks forward. This means that the legislator creates a law and the judge explains the meaning and applies the law as enacted by the legislative board. So a thing is prospective if it is expected to happen in the future. So law takes effect after they have been enacted and published. Because if not, if laws were retroactive, grave injustice would occur as it would punish individuals for violation of laws not yet enacted. For example of a prospective application of the law. So Law A provides that it shall take effect 15 days after its publication on, say for example, on August 15, 2020. The law takes effect on August 20, 2020, and will continue to take effect thereafter until it is repealed or struck down. So this is an example of a prospective application of the law. The purpose of the provision is that ignorance of the law only refers to laws that have already been enacted. So the obligatory force of law presupposes that it has been promulgated and made known to the citizen. Thus, a law that has not yet become effective cannot be considered conclusively known to the people. So the maxim on ignorantia legis non excusat is not applicable to laws not yet published and enacted. So what is a retroactive law? Retroactive means that the effect takes backward. A retroactive law is applied to facts or actions which existed prior to the enactment of a law. Example of a law which provides for retroactivity is that the Bayanihan to Heal as One Act of 2020. So the Bayanihan Act was enacted on March 24, 2020. It provides compensation of 100,000 to public and private health workers who may contract severe COVID-19 infection, and a 1 million pesos shall be given to public and private health workers who may die while fighting the pandemic. This provision provides for a retroactive application from February 1, 2020. So the laws shall have no retroactive effect unless the contrary is provided. So this article has exceptions. So exceptions to the general rule. First, if the law itself provides for retroactivity. Second, penal laws which are favorable to the accused. Third, if the law is procedural. Fourth, when the law is curative. And fifth, when the law creates new substantive rights. There are also exceptions to the exceptions. First is an ex post facto law. Article 3, Section 22 of the 1987 Constitution states that no ex post facto law or bill of attainder shall be enacted. So an ex post facto law is one which makes an act done before the enactment of a law criminal and punishable. It also aggravates a crime than it was when committed. And it changes the punishment and inflicts a greater punishment than the law. So for example, a law which makes eating 5 cups of rice illegal and requires the arrest of every person who has ever eaten 5 cups of rice even before the existence of the law. This is an example of an ex post facto law because it makes an act illegal that was legal when committed. Then second exceptions to the exceptions is if the new law will result in the impairment of obligation of contracts. Article 3, Section 10 of the 1987 Constitution provides that no law impairing the obligation of contract shall be passed. This is the case of Alfredo Tolentino and others, the petitioners, versus Antonio Alzate and others, the respondents. General Report Number L9267, published on April 11, 1956. Antonio Alzate, manager of an hacienda located in Nampicuan and Gimban, Nueva Ecija, filed a petition with the Court of Industrial Relations on August 12, 1954, to ask permission to lay off 19 tenants who were working in a 67-hectare portion of the hacienda to enable its owner to introduce a mechanization program, which would increase its production at a lesser cost beginning with year 1955 to 1956. The tenants, answering the petition, denied that the portion sought to be mechanized is suitable to mechanized farming. The tenants further said that the purpose of petitioner is merely to seek the ejectment of the 19 tenants to create an atmosphere of fear among them, who previously had filed a claim against the hacienda, seeking certain improvements in their tenancy relation. So while the case was set for hearing, Republic Act Number 1199, or the Agricultural Tenancy Act of the Philippines, an act governing the relations between landholders and tenants, was approved on August 30, 1954, 17 days after Alzate filed a petition to lay off 19 tenants. So Republic Act Number 1199 enumerates the causes whereby a tenant may be dispossessed of the land, among them being the desire of the landlord to cultivate the land through employment of farm machinery and implements. It was provided in the act that for the mechanization to be undertaken, it is necessary that the landholder shall at least 1 year, but not more than 2 years, prior to the date of his petition to dispossess the tenant. The landlord shall file a notice with the court and shall inform the tenant in writing of his intention and must secure a certification from the Secretary of Agriculture and Natural Resources that the land is suitable for mechanization. The tenants contend that because the landlord had not complied with the said requirements of Republic Act 1199, the tenants moved to dismiss the case on the ground of lack of jurisdiction of the industrial court. So the tenants filed for a petition for review by certiorari of a decision of the Court of Industrial Relations. So the issue of the case is whether or not Republic Act Number 1199 can be applied retroactively. So the ruling of the case. Petition was filed by Alzate to lay off 19 tenants for mechanization was filed on August 12, 1954, prior to the approval of Republic Act Number 1199, which was on August 30, 1954. Article 4 of Civil Code of the Philippines provides that laws shall have no retroactive effect unless the contrary is provided. The court said that a statute operates prospectively and never retroactively, unless legislative intent to the contrary is made manifest, either by express terms of the statute or by necessary implication. So there is nothing in Republic Act Number 1199 which would make its provisions operate retroactively, even with respect to the provision regarding mechanized farming. So the provision under consideration does not merely partake of a court procedure, but refers to a requirement which must be complied before the case be brought to court. Such provisions are substantive in nature. It is substantive because it establishes an obligation or a responsibility as manifested in the requirements that must be complied. So this cannot be given a retroactive effect unless stated in the law. So the orders appealed from are affirmed without costs. So this case is an example of a non-retroactive application of a law.